incorrect way to do it. And that's what I'm saying, is that how can I know, right now I'm looking at these, and I agree, I'm sitting there going through these last night, that there was some calls and who they were made to. I don't even know who any of this.
Well, I would submit, Your Honor.
But that's a PRA request of an in-camera review under a different proceeding, not a recall situation. I think we have, would you agree with me?
I would agree, Your Honor, that we could have done a better job in describing why this course of conduct was improper. And as it's in front of you now, I would submit that.
Because I don't see anything here. I have to tell you, this allegation, I'm looking at it and I'm going through it, and I thought I'd see like huge phone calls between all of these commissioners talking on their cell phones, and I don't see anything that's been given that even says that. It may be that there were huge phone calls.
Sure.
But that's a PRA request under the PRAs for an in-camera review for a judge at a different lake, and I don't have that.
I understand.
Okay, so I think that number 6, you'll have to agree, I don't have enough right here, factually, to say he violated the Open Public Records Act. Even as I sit here today, as I look to these cell phones, and I did last night, I looked at all your records, okay? Would you agree?
We appreciate that.
Okay. All right, let's go to number 7. Violation of the Open Public Record Meeting Act on September 21st by refusing to correct minutes challenged as inadequate of a prior hearing of September 1st, 2010.
Sure, Your Honor. So allegation number 7 is about an improper keeping of minutes. So I'll direct the court to Roman numeral 4, which says action discussion items, and the only explanation is matters of interest for all jurisdictions. No way for the public to know whether or not any business was conducted then or not. I direct the court to the date these were, so this refers to a September 1st meeting. My understanding is that these meeting minutes were recorded for the date of September 1st, but entered September 21st. A couple of weeks later, on October 15th, these meeting minutes were amended to include additional detail. And these supplemental, I guess we call them supplemental description of minutes, were later, they were not properly adopted by the board. They were just entered by staff. That we think is insufficient under the OPMA. And finally, allegation number 8. So the executive session that occurred here, the respondents concede that there is a narrow scope for an executive session. You can bring someone from the outside in to discuss the minimum price on a lease. But the minutes of this special meeting simply say public input. And this is
okay. Let's do it, because on August 16, 2010, they had a public meeting, but they went into executive session, which you contend they can do. You say that's okay.
Based on my understanding of what the subject of conversation, if it was in fact true, I mean, 423110C, I believe, allows an executive session for someone to discuss the minimum price of the lease. I believe that's what governs, and that's what.
Well, I always do it in terms of a business situation.
Okay.
If they can go into it to discuss certain criteria of a lease, which I assume this ADGER or ADAGE.
I believe it's a dash.
Was it? It was a lease somehow that the port's involved in somehow.
Well, right, and the purpose of the executive session must be consistent with the content of the executive session, and it is our understanding that that the public input refers to something much broader than just discussing the public input of the minimum price on the lease. And my understanding is that there is already.
But couldn't it be so much more than that? See, that's what I mean by executive sessions. I'm gonna give you an example, because I always do it in terms of how I do it. I see a lot of state cases, and they're talking about, giving tax benefits, to certain big corporations in order to do something, and they went into executive session. And it may be exempt under the PRA, and it also may make good business sense not to let a competitor, and what your Port of Shelton might be a competitor to the Port of Seattle. I'm just using this as an example of why people go into executive sessions, and that is a business rationale. And isn't that okay?
Well, the statute and case law pretty clearly allows the public to say that. And that's what all of these allegations are about. Whether
Okay, so you are telling me nowhere can they ever go into executive session?
I'm not saying that, Your Honor.
Okay, so what are you saying?
Well, what I'm saying is that
This executive session was wrong because what?
they exceeded the scope of who can attend the executive session and what was discussed there. And they got a specific report from the auditor. Again, I referred to this earlier, and this also applies.
They exceeded their scope by allowing too many people to come into this to not really make it an executive session. Is that what you're saying?
No, by the representative from Adage to enter and to discuss a subject that exceeded just the issue of minimum price release. And this, along with allegation 7, which I already mentioned, discusses the meeting minutes. The state auditor's report specifically advises the commission to do a better job of taking more detailed minutes. And so, and with specific reference to the executive session as well, to be clear about what's happening. And so, in an executive session. And so, those are the 8 allegations. I'm sure everyone's done them. We're excited, especially the court, having gotten through those. But I'd like to just again point out, these should all be taken as a whole, and the auditor's report should be taken notice by the court, because the auditor specifically advised the commission to address some of these issues that have been raised here. And the citizens are upset because they have.
Okay, and this is the report that you attached, the report of accountability on October 5th, 2009?
That's right.
Thank you.
Okay, we'll leave it to the respondents if they'd like, and reserve some time to respond if the court will allow.
Appreciate it, Council.
Good afternoon, Your Honor. Jeff Myers. I represent Commissioner Jay Hupp, who is seated here to my left. In addition, his wife, Diana, is in the audience as well. Commissioner Hupp was elected with 68.42% of the vote in 2007. And the purpose of this hearing is to determine whether the results of that election should be essentially overturned and whether there is sufficient cause to go to a new election.
Well, I'm just here to see. Number one, is it factual or legal sufficient to let the citizens do their thing? I'm not here to say, let's overturn it. I don't even vote in Mason County. That's for Mason County voters.
I understand that.
Let's go.
A couple things that I wanted to point out. Mr. Donkers mentioned that he believes there's a low standard. I don't believe there's a low standard. I believe it's for this court's role to act as the gatekeeper, as the West case pointed out, to make sure that there are not frivolous allegations and baseless allegations seeking to overturn elections. And so the case law, I don't believe, supports that. In the Estee versus Dempsey case, the court expressed great reluctance to uphold petitions where technical violations of the Open Public Meetings Act were alleged, which wasn't the community's underlying cause for seeking the recall. I think the underlying cause for seeking the recall here has to do with the Adage proposal itself. And as a visiting judge, you may not be aware of the dispute in this community over the adage biomass incinerator.
I'm sorry, I don't know anything about a Dodge.
And I want to just give you a little factual context, because the opponents of that were very upset that the Dodge lease option, which is the subject of these recalls, was not adequately considered in their judgment. They're essentially upset because two of the port commissioners, Commissioner Hupp and Commissioner Wallachner, refused to kill that project. That project went to a lease option. One of the conditions of that lease option is that it undergo environmental review, get permits. And that's an ongoing process that the community is going to have to deal with.
But that's not.
But that gives you a little context as to where the petitioners are coming from and what some of these charges actually mean. And that's why I present that. If we turn to these, the other thing that I think has been glossed over is what constitutes improper conduct. These allegations are very peripheral. In one or two of them, they allege a violation of a statute, and certainly a violation of the law, if it's intentional, constitutes a basis for recall. They haven't shown any intentional violations of the law. We'll get to that.
And that's what you say in your brief, and I want to make sure that you have time to respond to it, because what they're saying that the petition mentions facts that show a clear intent to commit an unlawful act. And that's what you said in your briefing, and I want to make sure he has time to respond to that.
Absolutely, Your Honor.
Okay, let's just go through these charges. I mean, you can
I
argue all you want to me about whether it was a good business decision, but the question becomes let's just go through these charges.
Whether it's a good business decision is something the court commissioners get to decide. This court is going to look to see whether the recall charges are factually and legally sufficient.
All right, charges 1 and 2.
Charges 1 and 2.
That's the retention of audio recordings. Am I right or not?
That's correct. It has to do with the
It's not the
retention of audio.
DVDs that I'm watching.
No. The charge here is that at the June 1st meeting, there was an illegal motion. That's what the petition itself alleges. I think it's very important to look at what the petition actually alleges, because that's all we can respond to. And now we hear that that is, in fact, incorrect.
But what you're saying,
And that
even
it should be
if
modified.
there was an illegal motion, the motion did not pass.
Correct. And
So let's say he moves to do something, but if the motion doesn't pass,
there's no action taken. And so
that's
there's-
what you're saying.
That's one of our contentions. One of our contentions is that the allegations are internally contradictory. And to the extent they were internally contradictory, counsel has now come before you and said it wasn't an illegal motion to destroy records. It was actually a motion to preserve records that didn't pass. And they have agreed that that was the actual motion. The fact that it didn't pass is not grounds for a recall. The motion itself, according to the minutes, was to preserve the records for 2 years. Now, commissioners can have lots of reasons to vote against a motion. One good reason to vote against Commissioner Miles' motion is that 2 years is not enough time to preserve the records. And if you look at the resolution that was then adopted on July 6th, Resolution 10-3, that preserves the records for 6 years according to the records retention schedules that the Secretary of State has adopted. And that resolution is attached to Mr. Hupp's declaration.
Okay, I have the declaration. What exhibit is it?
It's Exhibit 1. And if you look at paragraph 4 of Resolution 10-3, it says audio recordings will be kept for a minimum of 6 years in accordance